As you are aware, Madam Gail Teixeira, Attorney at Law Anil Nandalal, and myself, Bishop Wan Ejel, attended the talks this afternoon with the representatives of President Granger, specifically to deal with the appointment of the chair of GCOM. This afternoon we were presented with 8 names which were suggestions from the President. The names are Stanley Ming, Katz Khan, Kim Kite, Cassandra Alves, Dr. Aubrey Armstrong, Justice Claudette LeBennett, Justice James Patterson, and Justice Stanley Moore. My colleagues, Anil Nandalal and Gail Teixeira, will make some statements, and then we will take your questions. Mr. Anil Nandalal.
Thank you very much, Bishop, and thank you, members of the press, for attending this press conference. You heard us speak a few moments ago, immediately after the conclusion of the engagement with members of the government team. At the time when we spoke under some degree of restraint, having regard to the fact that we told you that we are simply delegates of the leader of the opposition, and that we would have to brief the leader of the opposition before we actually speak properly and adequately to the media. We returned to the office of the leader of the opposition and we briefed the leader of the opposition on what transpired, and therefore we were authorized by the leader of the opposition to speak more expansively and extensively in relation to what transpired. Now, the Constitution of Guyana is very clear. The leader of the opposition has the principal and fundamental duty and function to submit 6 names to the President for the President to consider for appointment as the chairman of GCOM. Those 6 names, however, must meet the acceptability of the President. The only other obligation that the leader of the opposition shoulders in the Constitution is that he must consult with other parliamentary parties in the National Assembly. Non-governmental parties, in the National Assembly. In this case, there is no other non-governmental party in the National Assembly than the PPP. So the leader of the opposition responsibility is very clear-cut. Of course, we have in the interregnum the interpretation given to us by the CCJ. Now, the CCJ could not have and did not alter, modify, or amend Article 161.2. All that the CCJ did was to guide us with some principles in terms of how that article can be operationalized. If you examine the judgment of the CCJ, you will see that the term good faith is used in excess of 30 times total in the judgment. Good faith being what the leader of the opposition and the President is supposed to act on in their engagement. It is against that backdrop that we began the engagement that we began, and it was clearly decided at the July the 4th meeting that we will submit a list of the same list of 18. We will submit an adjusted list from those 18 names to the President for the President to consider having regard to the fact that his consideration of those 18 names were found to be improper and flawed by the CCJ. We adjusted the list, and that's how we arrived at 11. We took out from the list persons who may have been overtaken by events. For example, one person became an active litigant in the process, and thereby we felt that person may be disqualified by that, his participation in those proceedings. Other persons withdrew their consent, etc., from the process. So the list was adjusted and 11 names were submitted. It was our clear understanding that we were going there this afternoon to consider those 11 names and for the government to indicate, or rather the president's nominees and delegates on that, in that engagement, to tell us which of the 11 names the president finds acceptable and which he does not find acceptable. Lo and behold, when we get there, we are confronted with a list from the government side or from the president's side, and the members of the president team informs us that they have no instruction in relation to the 11 names. And that, we believe, violates the good faith which is intended for this process to succeed. The president told us very clearly that he would like this process to be completed in a matter of days, and we welcome that commitment. And here it is, at the very first meeting, the president delegation has no instructions in relation to the 11 names that he invited us to submit for his consideration, but instead puts to us 8 names of his own. That does not augur well for the continuation of the process. And unless we have a commitment before tomorrow afternoon that the government is committed seriously to inform us at the tomorrow afternoon engagement that they will formally consider those 11 names and we can have some kind of result to bring back to the leader of the opposition, then we will not be persuaded that the government is acting in good faith, and we will not be persuaded that the process is being constructively pursued. Now, we don't wish to cast any aspersions on the names submitted, but the names have been revealed, and look at those names and you will see among those names are persons who are highly politically connected to the government. Now, the president, even before the ruling of the CCJ, had articulated certain qualities that he would like to see in the nominees submitted by the leader of the opposition. He said that they must have judge-like qualities, and he expounded that to mean that they must be persons who are impartial, who have integrity, who are above the political fray, etc., etc. If that is the government's, if that's the president's position, and he wants the leader of the opposition to submit names bearing those qualifications, then one would expect him to reciprocate and put to the leader of the opposition names of the same caliber and pedigree. But look at the names of the persons who are there. Many of them, as I said, have clear political connections. Again, I highlight that to you, not to impugn the character of the name, of the person's name, but simply to demonstrate that the government may not be acting in the good faith that they say they are committed to act by in this process. So, and the last point I want to make before I close is that when the CCJ spoke about the president having a say in the suggestion of names, it was in an informal way of names being floated across the table in a discussion that was fluid and ongoing. not a formal submission of names that will now cause the leader of the opposition to consider and reject. The leader of the opposition has no power under the constitution to reject these names. So they have put the leader of the opposition and the constitutional provision in an invidious position. They have turned the constitutional position on its head by submitting names for formal submission to the president. These names were supposed to be floated in a fluid way so that the leader of the opposition would in turn take those names, and once agreement is arrived at in relation to them, put them along with on a list of his constituting 6 and return them back to the president, so that both parties at the end of the process would have 6 names that each has confidence in. But that is not, I dare say, the way that the process is engaging. And we just thought that we will put that out there for the Guyanese people to understand the process every step of the way, so that you are better informed in relation to what is transpiring. I'll stop there, and Mr. Shearer can continue.
Well, thank you very much, Anil, and thank you, Bishop Edgell. We went to the meeting in good faith. You will know that after the July 4th meeting, there were some key issues and key agreements that were reached. One was that there would be this informal process, which the leading opposition was not averse to names coming forward from the president in an informal way for the leading opposition to consider. It was also further agreed that we would have small teams that would meet, and it was considered one time that it might be in the discussion with the president and leading opposition. It could be directly between the 2 gentlemen and or a small team on each side of 2 persons. We also committed at that meeting, based on the discussion, to submit as a starting point the 18 names appropriately adjusted. These were the words that we used, appropriately adjusted based on availability, people change their mind, and whatever. So those 3 issues that came up on July the 4th were dealt with. Furthermore, even the president, in his press conference, stated that Mr. Patterson was electoral history when it was raised by, I think, the media in that press conference. So that when we came to the meeting today, we were surprised to be presented with 8 names. But I want to remind the media that on Saturday, by Friday night, we had contacted Mr. Harmon to say that we would be submitting our names as appropriately adjusted on Saturday. That letter with the 11 names got to Mr. Harmon's office by around 2:30 on Saturday afternoon. We also put forward the names of the persons on our team, and then the government put 3 people. We increased our representation to a 3rd person as well. But what is interesting is that, therefore, the government had 48 hours, Saturday, 2:30, around 2:30, 2:40, to 5 o'clock on Monday, a little over 48 hours, in which they were able to examine the list and for the president to indicate what was acceptable, what was not acceptable on the list of 11. When we went to the meeting, we were confronted with a list of the 8 names, which I see Mr. Mosley, I believe, has publicly gone, and we were under the impression that we were not going to do that, but anyway, it's been done, so the names are out there. The interesting thing about when we got to the meeting, it appears as if the government side, the president's representatives, appeared to want to move full steam into the 8 names, and we made it very clear that we had to look at the 11 names. We had never known why the president rejected the 18 names. We've never been privy to that, nor has the public of Guyana, and that the CCJ has made it very, very clear that reasons must be given for rejecting a name by the president. The important thing, I think, too, is to be recognized is that the president himself recognized in the meeting on July 4th that the Constitution was not changed. The Constitution remained intact as of of July 4, 2019. The CCJ did not change the Constitution. They obviously can't. And that he even said that, you know, in submitting names, how could he be submitting names and then approving the same names afterwards? And so, whilst we were not averse, and the leader opposition made it clear he's not averse to the president suggesting names informally to him for his consideration, that this would in no way be a way of what you call tying his hands, or tying the leader opposition hands. I think that today is unfortunate, and this is not a good indication of good faith efforts. A lot of time was available to the government and to the president, I'm sure, and we were shocked that when questioned, why can't we go to the list of 11 names, that, and let's start there, as agreed to on July 4th, and that would be the commencement of the process, that Mr. Harman then indicated they had no instructions from the president on the 11 names. And this, I'm emphasizing what Anil said, because again, we meet and make, we have discussions with the president and his delegation. We go in with good faith, and then when we end up in the process, we are finding from the very first moment that we are being caught in a situation where they're not acting in good faith as far as we're concerned. One of the things I wanted to raise outside of today was that how did the 18 names come about in the first place? To remind you, Bar Jagdeo is the only leading opposition from the time when the Carter formula was brought about and made into law in the 90s. He's the only leader opposition, other than Chetty Jagan as a leader opposition, who consulted broadly with the political parties at the time in 91, and again with Jagdeo in 2017, with civil society on the names to come forward. And out of that process, we got about between 50 and 60 names, and the leading opposition selected out of that 6 names, then the second 6 names, and the third 6 names. For the president now to be imposing, in a sense, 8 names, and not allowing us to go through the 11, which was the beginning, I think these are not indications, these are not good indications that the government is serious about moving forward. We're prepared to go tomorrow at 4 o'clock, and we're prepared that we expect that they will advise us on the 11 names, as we agreed on July 4th, as we agreed today again, that we would go through the 11 names and then we would look at the 8 names. However, we made it very clear that we cannot speak for the leading opposition. It is, the Constitution gives him the power to determine which names go forward, and he does not have to give reasons for why he accepts or doesn't accept a name coming to him. So just like when we did the civil society consultations, and there were 60-odd names that came of us from religious and Amerindian organizations and women's organizations and trade unions and lawyers and so on, that ultimately he extracted from those names the names he thought would be able to manage the electoral machinery of this country. And so it's important that I think the public out there knows that we are acting in good faith, but if the government does not act in good faith, then we will be put in a situation where we will have to not participate in this process.
Thank you, Mr. Nandalal and Madam Chair. We'll now take your questions.
Yes. Right.
And that the president would also, the opposition leader had no issue with the president submitting names as well. How come this comes as a surprise that names were submitted from the president as a suggestion? And secondly, don't you think it would have been better to, or it is best to submit, to consider all of the names? I think you now have a total of 19 names.
Well, that's what we're going to do tomorrow, but the first list is the 11.
But I think a fundamental question.
Yeah, go ahead.
A fundamental question is, if 18 names were submitted and in the meeting of July 4th we agreed to tweak it and to bring it down to what is current, and we have a list of 11, without the president offering an objection to the 11, where we could get 6 out of the 11, we don't see a need arising for 8 other names. So, is the submission of 8 names an indirect statement of the rejection of the 11, of which Mr. Harman says the president has no view at today's meeting? The
Hasn't given
place to
instructions.
start is the leader of the opposition submits a list, the president to pick one, so that we could have a list that is not unacceptable to the president. The leader of the opposition, formally by way of writing, sent a letter with 11 names to the president. They had 48 hours to consider that, to come and say, you know what? These 11 are not unacceptable, or they are not acceptable to the president. You may want to consider these 8, but that's not what took place. They're saying, add 8 to the 11 and let's start considering. It's like if you're horse trading and you're not following the constitutional guidelines. And I think that needs to be made clear.
And an additional point, if I may, is that time is of the essence, and the president himself indicated to us and the country that he would hope that the process would conclude within a matter of days, his exact words. If that is the president's true feeling, then why couldn't these 8 names be communicated to us before, so that the leader of the opposition would have had an input and we would have been properly apprised and properly instructed, so that when we go to the meeting, the engagement would have been a constructive one, and not one where we are confronted for the first time with a list of 8, and you have our 11, and you don't have any view on our 11, but you have 8. I mean, we can't be operating at cross purposes. If we are meeting and time is of the essence, and we are genuine and we are acting in good faith, then each side must attend a meeting willing to contribute and willing to make a constructive output and input. What we went there for? All we went there to do was to receive 8 names. I could have gone home and do other things.
I think that the journalist is asking the question too, is that no one sees anything wrong. We have said it over and over again. It's in writing and in the public. The leading opposition is not averse to the suggestion of names by the president, and informally, in keeping with the Constitution. The Constitution doesn't provide for the president giving any names, but in the process of good faith, as the CCG suggested, gave guidance on the process, they said the first thing they must communicate and perhaps meet. And perhaps. And so the issue was that there's nothing to have stopped the government presenting the names to us earlier. And secondly, coming to the meeting in good faith, prepared to deal with the 11. Because that was the decision of July 4th. This is not an invention of JAGDE or an invention of the leading opposition office. This was an agreement of July 4th that we would commence the process with this resubmission of the 18 names, quote unquote, appropriately adjusted, to commence the process. And I want to emphasize that I sound like a broken record, but that is what we agreed to. And that is what we went to the meeting to do, to look at the 11 names and to learn maybe for the very first time which, if any, are not unacceptable to the president. Because remember the CCJ ruling, they said very clearly that the president must indicate his reasons for not accepting any of the names on the list. And in fact, they even go to the point that the leading opposition cannot anticipate or know what the president and why the president is rejecting a name. And they pointed out that the public needs to know that too. These are all names in the public eye. These are all people in society and are prominent people. So we went in good faith, and I think that our shock was, that first of all, as soon as we arrived, we were given 8 names. And secondly, that they seem to want to push to deal with the 8 names first. And thirdly, when we said, well, the agreement was the 11 names, well, 18 names appropriately adjusted, can we discuss that? Then they said they have no instructions on how to deal with these names. So that, again, we go back to good faith efforts. And so we are serious about trying to get this done as quickly as possible. However, we lost between when our office submitted 11 names on Saturday at 2:42. I have the timesheet when it was delivered to the Ministry of the Presidency. I may have got the numbers quite wrong in the number of minutes, but I know the hour. And I confirmed that with Mr. Harmon, confirmed he got the letter, the hard copy. What happened to yesterday? What happened? Is this a government that only works Monday to Friday? Is this a public servant type government that doesn't work on the weekends on a political issue that's of critical importance to our country? We have a CCG ruling that says you gotta have, you gotta set this up, you gotta do it, and you have a president at the same time saying that he cannot pronounce the date of election until there's a chairman of GCOM. So again, we're back in the waltz between now a non-existent chairman and a president, not wanting to set a date because there's no chairman of GCOM. Before there was a chairman of GCOM and he didn't want to set a date because he was waiting on the president to set a date. So this is again our deep, profound concern of continuous obstacles to holding elections in compliance with the CCJ ruling. And so this is not acting in good faith. I believe the government feels very content with themselves today. They were very pleased with themselves today. But this is not good for the country and it's not good for the people of our country. So the issue of the chairman of GCOM has to be addressed. It has to be addressed, and it has to be addressed in a way. Obviously, there is no requirement for the president to provide a name. It is Mr. Jagdeo agreeing that he's not averse to the president suggesting names in the interest of consensus and in the interest of how the CCJ has written their guidelines, or a guide. But we also cannot be playing cat and mouse games in this place. The issue is the Constitution puts the remit into the leading opposition hands, and it makes it very clear, as the CCJ does, that the president has to select a name from that list. I saw in the press conference the president's continuing to repeat that he can use the proviso. He can still use the proviso even if the leading opposition prevents a list, which was what got him into trouble in the first place.
That's why we went to court.
And that's why we went to court, and the court vindicated our position, and the president repeats it again. And in the meeting today, again, they talk about proviso. And so the issues are that we're very concerned, and we hope that the government, and again, we had to remind them in the meeting, that they're not, in the meeting, the two groups, we are representing the leader of the opposition who has a constitutional mandate. The team on the other side is representing the president. They're not representing the government. The government has no say in the approval of names for the GCOM chairman. It is the president. And it is not the parliamentary opposition that has a say in submitting the names. It is the leader of the opposition. And so this whole view, when the names are submitted to us, it says names proposed by the government. There's no such thing in the Constitution. It does not give the government any such power. It gives the president and the leader of the opposition. It may sound like a semantical argument, but we know where it's heading when they start playing with these words. And so we take very seriously what's happened, and that the names that have come out, as you will see for yourselves, I hope that some of you who may have commented, some of the media who may have commented on some of the names on the 18 list who you felt were politically tainted, that you will have a close look at the 8 names, and you may want to consider if any are politically tainted. And so we have balance and fairness in the assessment of the names. But we are not in a position to answer any questions of whether any name is acceptable or not. That's not our remit. That's not our remit. And it is not for the leader of opposition to reject any name. It is for the leader of opposition. When he gets the names, he will extract and submit to the president the names that, as much has been pruned from the 19 names and any other names that come up. Any other names. And we made it clear that we are prepared to add additional names. The first tranche were the names of those from the original 18. But that was not to be the end of the process. So we're prepared to bring additional names and to look at all the names in the pot.
Just for clarification, when you meet again tomorrow, the opposition leader side, are you open to considering all 90 names, or are you be focusing only on the 11 names?
The agreement we have is at first we commence as we agreed to from July 4th, and that is to commence the examination of the 18 names appropriately adjusted. That's the first step. And any other names that come through the process, including names suggested by the president. But the first thing is to start with the 11 names that are submitted already and to be given reasons, if any, as to their acceptance or rejection.
And fundamentally, once the engagement commences, the proviso cannot be activated.
Right.
That is the clear pronouncement from the Caribbean Court of Justice that the president cannot make a unilateral appointment exercising or purporting to exercise any power under the proviso once an engagement is ongoing between him and the leader of the opposition. That is exactly what he did on the last occasion, and that is precisely one of the flaws identified by the CCJ in the process.
Right.
And just to indicate that on the CVs, which I guess the president would have read, at least two of the applicants, two of the persons suggested, it did indicate that they had political association and stated which party they were politically affiliated with in the CVs.
Full disclosure.
Full,